My dear friends, you are welcome to the second edition of our running series of public lectures on the journalist and the law. Last time we talked about arson. Today we're going to talk about something different. This time it is murder. A few years ago, I wrote this book entitled, Was He Killed or Was He Murdered? A Journalist's Guide to the Law and Legal Reporting in Cameroon. But today I'm not going to talk about this book. I just gave you the title as an indication of what I intend to discuss on the program today. Murder is sometimes very critical. And when journalists report incidents where someone has been killed, the tendency is always to say a man has been murdered. The journalist has to be neutral at all times, use words that are neutral and not words that indicate the direction that criminal prosecution is supposed to follow. Let me take the example of the young teacher who was killed at the Nkobison Government High School. And many journalists reported, many media houses reported that the young man had been murdered. Now, they were supposed to say the young man had been killed because there are so many different kinds of killings. I take that again. Because there are different types of killings. Murder is just one of them. In the case of the young man who was killed at the Nkobison Government High School, 3 possible charges could be brought against the perpetrator, at least as far as the facts that we have at hand now are concerned. The first, it could have been murder. Number 2, it could have been capital murder. And number 3, it could have been assault occasioning death. These are 3 possible charges that could be retained against the perpetrator. Therefore, it is not okay to rush and say it is either murder, capital murder, or assault occasioning death. I'm going to explain each of these 3. For murder, it is the causing of someone's death. Murder is causing someone's death. That is murder. For murder, both the act, that is to say, it could be a blow or the assault, was intended, and also the result or the consequence, which is the death, is also intended. I repeat that. For murder to take place, both the act of the perpetrator and the result or the consequence of that act must be intended. That is to say, both the blow, the assault, and the fact that the man died should have been intended by the perpetrator. And murder is punishable under section 275 of the Penal Code of this country, Cameroon, with imprisonment of up to life imprisonment. For capital murder is the same like murder, but in addition to the presence of some circumstances, murder can now be declared as capital murder. There are about 3 conditions that can make murder to become capital murder, but I will discuss only one of these conditions for the purpose of this public lecture. And that is the first one. It is called premeditation. Premeditation simply means that there is a lapse of time from when the perpetrator decides to commit the act to when he or she actually commits the act. There should be a period of time, long period of time, from the time when the perpetrator decides to commit the act and when he or she actually commits the act. A lapse of time which gives him or her a period of reflection that could lead him or her to abandon the scheme. So when there is that premeditation, that is to say you kill somebody after having reflected for a period of time, because of that period of time, the murder now becomes aggravated and it is called capital murder. And according to the Penal Code of Cameroon in section 276, anyone guilty of capital murder, the punishment is death. That is the highest punishment, death, capital punishment. The third one now is assault occasioning death. For assault occasioning death, the perpetrator intends the act, but not the consequence. I take that again. For assault occasioning death, the perpetrator intends to commit the act, but doesn't desire necessarily the consequence or the result of the act. Take, for example, you beat up your wife at home, you beat up your child at home, and because of the beatings, they die. That is assault occasioning death. You wanted to beat them, but you did not intend that they should die. So you intended the act, but not the consequence. But for the first two that we discussed, the perpetrator intends both the act and the consequence. So under this third one, you cannot complain that no, you didn't intend to kill them, because according to the law, you must take your victim, talem qualem, as you find him. It could be that they have a weak heart and they are not able to sustain such severe beatings and they die in the process. That would be assault occasioning death. So you see, these are three possible charges that could be brought against the perpetrator of the killing, or the person who killed the teacher at the Nkobison Government High School. So it would be wrong for the journalist to rush and classify the act under any of these heads. Under the laws of this country, it is only the state council, the prosecution, the state council, who is authorized, empowered to classify offenses. So when that act occurred, the only person who can decide that it was a murder case, capital murder case, or assault occasioning death is the state council, the prosecution. Nobody else is empowered to do that. Talk less of a journalist. So to be on the safer side, journalists are supposed to have said that the man was killed and to allow the prosecution to go ahead with the classification. Once the classification is done, they can now begin to report that it is murder, capital murder, or assault occasioning death. If they proceed with the classification, like many of them did, then it will be a travesty of the legal process in Cameroon. So it is wrong. So use the neutral word killed, not murder, not capital murder, not assault occasioning death. Now, I still want to stick with that same example because the circumstances of that particular incident opens the way for us to discuss another important issue, the perpetrator of that act, the alleged perpetrator, because until he or she is proven guilty, he is presumed to be innocent. So we say the alleged perpetrator. The alleged perpetrator of that act at the Nkobison Government High School is what we call in law a minor, a juvenile. Now, who is a juvenile? The laws of this country do not specifically define who a juvenile is. So we have to make recourse. We have to seek solace in international law. Now, there are two instruments I would like to bring to your attention here. The United Nations Convention on the Rights of the Child in its Article 1 and the African Charter on the Rights and Welfare of the Child in its Article 2 defines a child as any person less than 18 years old. Any person less than 18 years old is considered a child, a minor. Our penal code in its section 80, in the various paragraphs of section 80, now explains the degree of criminal responsibility of children who are below 18. That is from those who are below 10, 12, 14, and below 18. It now explains the degree of criminal responsibility of each of these categories of children. And the two instruments which I gave you, they are part and parcel of Cameroonian law by virtue of section 45 of the Constitution of this country. Once Cameroon ratified those two instruments, they become part and parcel of the legal corpus of Cameroon and have to be applied as such. Therefore, Following this logic, the definition of a child, according to the two instruments I cited, hold true for Cameroon. And so therefore, in Cameroon, we also consider a child to be any person who is less than 18 years old, less than 18 years of age. Now, when you are reporting any incident, any criminal offense that concerns people who are less than 18 years of age, there are some restrictions to media people. They are not supposed to report everything. The most important one is that they are not supposed to disclose the identity of the child. Even though in Cameroon we don't have well-designated juvenile courts, but Section 713 of the Criminal Procedure Code converts the court of first instance into a juvenile court to try all felonies, misdemeanors, and simple offenses committed by young people. And Section 720 of that same Criminal Procedure Code stipulates that when a trial of a young person is being conducted, it must be in camera, behind closed doors. It means that the public is not supposed to be invited into the trial. Only the parents of the child, maybe social workers and the judges and lawyers of the child are supposed to be present in court. It is supposed to be in absolute camera, closed doors, and no report on the proceedings are supposed to be disclosed to the public. The identity of the child must be concealed. You must not give indications as to what his name is, where he lives, or who his parents are. That is forbidden for journalists to do. So far, when the incident occurred, many journalists violated these rules. But as the trial will go on, it's important for journalists to understand that they are not supposed to violate these rules of secrecy, because these are the protections that have been afforded by our law to young people, juveniles who are less than 18 years of age. Now, if you violate this law as a journalist, in the media houses, you publish the identity and disclose photographs, still or moving pictures of the alleged perpetrator, you are guilty of an offense which is punishable under Section 198 of the Penal Code of Cameroon, and you can pay a fine of up to 6 million francs. Take note, you can pay a fine of up to 6 million francs if you disclose the identity of the juvenile and you report in a way that helps people to identify who this young man is. When this incident occurred, some media houses went to the family home of the alleged perpetrator and talked to neighbors, and they said all kinds of things. That is, it was emotionally charged. Many people liked it. But then, from a legal standpoint, you vitiate the fair trial of the young man. Because any judge who watches those pictures, those testimonies, might be influenced by what the people who made the testimonies in that media report said about the young man. And so the young man might not be guaranteed a fair trial. A fair trial is guaranteed to everybody under the Constitution of this country, the Constitution of 1996. And the law has also given other guarantees, like I have just indicated to you, guarantees that protect the young offender, the juvenile offender, who must not be considered on the same footing like an adult perpetrator of an offense. An adult perpetrator of an offense. So journalists should be on the watch out. Let me summarize the two important points we have discussed. When somebody dies out of a criminal action, don't rush to say the man has been murdered. Say the man has been killed. Except the police tell you that they're going to charge for murder or whatever other charge they might want to bring. So use the neutral word killed. Secondly, if the offense concerns a minor, a juvenile as we have defined, don't disclose the identity of the minor. You can report about it, you report about the judgment if eventually it comes, but don't write anything that will disclose the identity of the minor. So I want to thank you. I hope you learned something in today's edition. If you have any contributions, suggestions, or questions, send them to the email address and the telephone number you have below the screen, which can also be used for WhatsApp messages. Until next time, goodbye.